Good afternoon, everybody. On behalf of the Voting Rights Institute, which is a project of the American Constitution Society, the Campaign Legal Center, and Georgetown University Law Center, welcome. My name is Jill Dash. I'm the Vice President for Strategic Engagement at the American Constitution Society. We started the Voting Rights Institute in 2014 in the wake of Shelby County versus Holder, which we predicted then and now know would be catastrophic for voting rights. We're here today to evaluate the state of voting in the wake of the first presidential election since Section 5 of the Voting Rights Act was struck down. There are many things to be concerned about following this election, but the attack on the right to vote is the most fundamental of those concerns. The aim of the Voting Rights Institute was to recognize that we would need more lawyers in the fight for voting rights going forward, and that has never been more true than today. Since the founding of the Voting Rights Institute, we've held 15 trainings of approximately 700 lawyers and law students across the country. We have just begun to wade into this issue, and we need your help. So I ask you to leave here better informed, if concerned, and most importantly, energized and willing to engage us in this fight, because we do need each and every one of you. And most immediately, you need a moderator, which is why we bring you Paul Smith. Paul is the chair and appellate and Supreme Court practice and co-chair of the Media and First Amendment and Election Law and Redistricting Practices at Jenner & Block. He has had an active Supreme Court practice for 3 decades, including oral arguments in 19 Supreme Court cases involving matters ranging from free speech and civil rights to civil procedure. He has spoken at several of our Voting Rights Institute trainings, so he is a good friend of this program, and we at ACS are very fortunate to have him on our national board as well. Paul.
Thanks, Jill, and thank you all for being here. I think we have a wonderful panel with great knowledge about an obviously relevant and important topic. I will introduce each of them as we get to their little section of the program, but just to mention who we have here: Julie Fernandes, a national expert on this subject; Anita Earls, a wonderful civil rights attorney from North Carolina; and Kathleen Clyde in from Ohio. And they're each going to have very interesting and different perspectives to offer on the question of whether and how votes were suppressed in this last election. Now, before the election, of course, there was a great deal of concern that this might be the election where the presidential outcome was determined by who was allowed to vote and who wasn't allowed to vote. That may have been true, but it's a little hard to argue that it was true in this particular instance, the way things turned out. But it certainly is true that there were plenty of problems in the way the system operated, and some down-ballot races were no doubt affected very significantly in terms of the barriers to voting that we're going to be talking about. In any event, the electoral system of this country is a matter of some interest to everyone in this room, I'm sure, in the week we're here. And we want to talk about it and get to understand it better. And so let me start by introducing Julie with the full introduction that she so richly deserves. Julie Fernandes is the Advocacy Director for Voting Rights and Democracy at the Open Society Foundations, where she works to influence public policy in support of the protection of civil and human rights in the United States. Now, prior to that, Julie was Deputy Assistant Attorney General for Civil Rights at the Department of Justice, where she was responsible for overseeing the voting rights program. And for more than 6 years before that, Julie was a senior counsel at the Leadership Conference on Civil and Human Rights. She also served as a special assistant to President Bill Clinton at the White House Domestic Policy Council, was counsel to Assistant Attorney General for Civil Rights, and spent time as a trial lawyer in the housing and voting sections in the Civil Rights Division. She got her bachelor's in law degree from University of Chicago and clerked for a wonderful judge, Judge Diane Wood, on the Seventh Circuit. And like me, she's on the board of directors of the American Constitution Society. So, Julie, why don't you start with an overview of where we are in this country with the law of the right to vote since Shelby County?
Okay, where are we? So thank you so much, Paul, and ACS and the Voting Rights Institute. I'm really happy to be here today to talk to this group about this question of where we are and where we are with voting rights and our voting rights laws and what it looks like from where we sit today on the 15th of November. And I think one of the questions that you just noted a second ago, Paul, that was sort of in the air is, did voter suppression play a part in the outcome of the election? And I, maybe like Paul, think that that's not the right question. The question that we should ask as voting rights lawyers and advocates is whether voter suppression denied voters the opportunity to participate in this election. Did voter suppression happen in a way that worked? The answer is yes. We saw voter suppression all over the country in this election, like we have in many elections. Are some of the tactics around voter suppression targeting African Americans, Latinos, and racial minorities? Yes, they are, and we've seen it happen. And did the Supreme Court help the voter suppressors in their work to suppress African American and Latino votes? Yes, big time. So here's what we know. Voter suppression is funny. Like in the lead up to the election, people were like, oh, we should be looking for that voter suppression on election day. Let's look for it. And I kept saying over and over again, you're going to see some of that, but you should have been looking for the past 2 years. Because the voter suppression that I think had the biggest impact on our communities is not what happened on election day. It's what happened in this lead up to election day. It's in the lead up to election day, it's like a slow leak that all of a sudden the bathroom is flooded because it's not that moment, it's all that happened beforehand. So what do I mean by that? Many things, but let's talk first about Shelby County versus Holder. In 2013, I'm not going to belabor it because I think this crowd probably knows what I'm talking about, but in 2013, June 25th, 2013, my oldest son's birthday, yes, I'll never forget
Very
the actual
important
date. Yeah, I know. 2013, the Supreme Court decided in Shelby County versus Holder that the strongest part of the Voting Rights Act, which is the Section 5 preclearance process, was no longer going to be operable. As we all know as lawyers, they invalidated the formula that determined which places around the country had the obligation to submit any voting changes to the federal government, either DOJ or the federal courts, for a determination that that voting change was not racially discriminatory. So what that meant is that no longer does jurisdictions have to have an anti-discrimination check on their voting practices before they're implemented. Why does it matter? Voting is so unlike every other area of the civil rights laws in that there is really no remedy for voting discrimination for people who are the victims of it. In a housing discrimination case, you don't give me the apartment, rent me the apartment because I'm black. So then my remedy, give me the apartment. And maybe I get some cash for my pain and suffering. Employment discrimination, you discriminated against me, you didn't give me the job. What's my remedy? I get the job. I get back pay. In the voting rights context, I'm denied the ability to participate in the election or to have my vote count in the election or to have my vote count equally to other people's votes in the election. What's my remedy? Do we get to start all over again? Can we like hit the reset button and then we have the non-discriminatory system that I get to participate in? No, my remedy is only if I can make the case my remedy is only prospective. And so the genius of the Voting Rights Act, Section 5, was it allowed this sort of determination to be made ex ante, which then we could say, okay, we're going to stop this from happening because there is no real cure. And that genius, that effective genius, was taken away for us in Shelby County versus Holder. Now, the other thing for us to remember here, so that jurisdictions were in many cases, and Anita will talk more about this in North Carolina, able to pass discriminatory laws with no real-time check and no stop on their implementation. Now, one thing that's also good to remember when we think about this work that we do is that the right to vote, maybe I should use the air quotes, the right to vote is something that has been a struggle in our country from the beginning. Let's not forget that who had the right to vote in the beginning, right? White men who owned stuff, property, and then maybe just white men. And then, oh no, how about women? Let's throw in, after a really long time, allow African Americans and Latinos to have the same right to vote that white people have. Thus the air quotes, right? That's what we have. We can have the same right to vote that white people have. And the struggle has always been about people in power trying to figure out who should have the power to take them out. Because the people in power that make the rules, and they get to decide who the electorate is. Because they get to decide who has rights and what those rights are, what the contours of those rights are. So we haven't had equal access really ever. We've been on a fairly slow march to try and get it. Certainly 65 was a threshold. Actually, 1993 was a threshold, too, was the National Voter Registration Act. The NVRA was a powerful statement about who should be participating in our democracy, because a big part of it was to try and capture not just everyone who renews their driver's licenses, which we all remember. That's what people think of. They always call it motor voter, but it was really also about the obligations on social service agencies to also provide opportunities for people to register to vote. So it is public welfare offices, disability offices, it's food stamp offices. Anything the state is running that's sort of like a social service agency, they also have to provide opportunities to register to vote and facilitate registering to vote. So, I mean, when the first time the NVRA passed in Congress, it was vetoed by George Herbert Walker Bush. And when it was repassed, it was the first bill that Bill Clinton signed into law in 1993, the very first, the National Voter Registration Act. And 6 Republicans voted for it. I would have to say, I would bet that they would all not be Republicans today. It was like Bob Packwood, people like that. So this is a struggle that's been ongoing for a really long time, and how are we dealing with it in this election? So my context is over. I know I'm talking too much. So part of what we lost in Section 5 that had reverberations of this election was, as we mentioned, the preclearance, but I want to talk about some other things too. We lost the ability really to know about what's happening. Because when we had Section 5, all these jurisdictions, it was like 25% of the country. It wasn't just kind of a tiny piece of the country. All are part of 16 states, 25% of the country, the places where we have the most history and current practice of racial discrimination in voting, they all had to let the Department of Justice know of every voting change they made. Every little thing. You move a polling place, you have to tell DOJ. You change the rules around registration, you have to tell DOJ. You tell them everything, so that there's always, not only is there sort of a process of an anti-discrimination check, but the process itself of sunshine made people act in ways that were more inclusive and more deliberative and more mindful of the racial impact of their decision-making. But when we lost Section 5, we lost that. So the mindfulness around voting changes and how they impact racial minority communities is no longer an obligation. I'm sure some places are still doing it, being mindful, but it's not something they have to do. The other thing that we lost was the Federal Observer Program. And I know there was so much great work done by the nonprofit community, by my colleagues, the NGO community, to sort of be present, and the Election Protection Program the Lawyers Committee runs is very important. But we really did lose this DOJ having a well-funded big force of lawyers in an election like the one we just had, where we had racially charged rhetoric, demonization of Latino citizens, all of this, lots of negativity and hatred in the air. You would have expected the Department of Justice to have the biggest deployment of people monitoring elections they've ever had. But they were hamstrung by the loss of Shelby. So in fact, they did send monitors out, people who had less authority and in smaller numbers, but you would have expected huge numbers. And instead, they were limited by the Shelby County decision. So the kinds of, I'm sure you all saw a lot of what was happening, and others can talk more about the specifics in their states, but the type of things where we saw big problems that could have been prevented by Shelby, where the biggest one, of course, is the voter ID laws that have proliferated in recent years, and the voter ID law in Texas. Texas is so interesting. I just came from a briefing that was talking about what happened in Texas in this election. I'm not an expert, so I'm just learning about a lot of this. I'm not a pollster. But Latino voters actually turned out really big in Texas. There was actually kind of a huge presence for the Latino community in Texas in this election. Even though there was a suppressive voter ID law in place in that state, and still, so they had voter ID law. It was held to be racially discriminatory by a federal court. Then Section 5 was invalidated. They had to bring a Section 2 lawsuit. Every federal court that's looked at the ID law has found it to be racially discriminatory, yet it's been in place all of these years. And even for this election, they had to negotiate an interim remedy, which many feel was still suppressive. So so this is like how Section 5 would have said you can't do it at all. In this world, we have a remedy that's kind of still an oppressive remedy. Even with that in place, we had huge Latino turnout in Texas. What could we have had for the Latino community if we hadn't had that? What did we lose in not having that? The last thing I'll mention, then I'll stop for the others, we can do a lot of questions, is polling place consolidations. This is a story that I hope folks here in the room are aware of. A polling place consolidation may seem like it's a mundane thing. When you wake up in the morning and you've always voted in a certain place and you go to vote there and it's not there, most people plan when they're going to vote. I'm going to vote, and I'm going to go in, I'm going to do it this time, and they'll be able to get in the office for this thing I'm doing, or my shift ends this time, I can go in to vote. Then you show up and it's not there. What do you do then? And there were a large number of polling place consolidations and polling place eliminations around the country, as there often are. There's been an acceleration of that in many places for lots of reasons. But in a world where there's no requirement that you have clear notice to the community, that you've consulted with them about the change, that it has been determined that the move is one that's not going to make it harder for the minority community to vote. That all didn't happen. So we have all these polling place consolidations, and it's unclear whether or not they were racially discriminatory, and no one's going to have the ability to figure that out now. So I guess the last thing I'll say is, when I used to do this spiel before the election, say, we've got 2 bipartisan bills pending in Congress that will fix the problem of the Voting Rights Act. They're both bipartisan, they're good bills. We could talk about how one is good and one is better than the other one. All of that is completely dead. I hate to say that because I'm such an optimist usually.
And you spent the last
Yes.
3 years working on
I've
that.
spent the
Right?
last 3 years of my life working on these 2 bills, which, they're beautiful things, but they're dead. They're dead right now. And that doesn't mean that our fight is dead, but it means that we have to think about what our fight looks like going forward to protect the right to vote in the states and at some point nationally. We have to have a movement around this that takes away my air quotes, so I never do that again. That when we talk about the right to vote, it's as sacred and as protected as the right to bear arms. Those right to bear arms folks, which I am not one of them, I do not believe in the individual right to bear arms, but the right to bear arms folks, they have like the well-funded militia is necessary, so you have the right to bear arms. We have the 15th Amendment, and we're less protected than gun owners. I'll stop.
Thank you, Julie. She cares about her topic.
I do.
Yes. So let's get more specific about what happened in a couple of really, really important states. The first one is North Carolina, which Anita is going to talk about. Anita Earls is a civil rights attorney, as I indicated. Prior to founding the Southern Coalition for Social Justice, she was director of advocacy at the UNC Center for Civil Rights and director of the Voting Rights Project at the Lawyers Committee for Civil Rights under Law. She served as a Deputy Assistant Attorney General in the Civil Rights Division, responsible for voting, educational opportunities, disability rights, and the coordination and review sections. And for the first 10 years of her career, she did a lot of this important work from private practice. And she is really the face of voting rights for North Carolina. So without further ado, Anita, tell us what's been going on down there. There's a few things to talk about, I think.
Yes, well, thank you so much, Paul, for that kind introduction, and thank you to ACS for bringing me here. I'm really excited about the chance to talk with you about what's been going on in North Carolina and a little more broadly in the South. One of the things that our organization does is head up a coalition of advocates around the South called SOLVE, Southern Leadership for Voter Engagement, and it's really a partnership of attorneys, grassroots activists, academics who are trying to protect the right to vote in the South. And I can talk a little bit about what we've been seeing in other states. But I do want to tell you the story of North Carolina, in part really to highlight ways in which attorneys in private practice or attorneys who aren't doing voting rights 100% of the time can fit in. Because in my little story about what's been happening the last few months in North Carolina, there's some key points where we really needed some attorneys able to step up and advocate for voters at short notice. So I do want to start with where this Voting Rights Institute started, and that is the Shelby County decision, because what happened in North Carolina the day that decision was announced is that one of our key legislators said, now we can go with the full bill. And what he was talking about was their vote suppression bill, that they couldn't pass when Section 5 was in place because it would have immediately been, it would have never gotten pre-clearance, but now that that Section 5 was no longer in place. They could go with the full bill. They did enact it in the legislative process. We put in the record evidence about how it would disproportionately impact African American voters in the state. And their full bill was more than just voter ID. They changed the voter ID provision to dramatically restrict the types of IDs that could be used, but they also eliminated same-day registration at early voting, which was the main way that North Carolina had helped equalize the turnout between African American and white voters in the state. They also cut back early voting. They eliminated pre-registration for 16 and 17-year-olds. There's simply no justification for why they needed to do that. Other than that, the data showed, actually, that African Americans more often took advantage of that, and that was their path to registration. So there was litigation the day the bill passed, cases filed in federal court, the Department of Justice filed a lawsuit. Trial court ruled that all this was fine, consistent with the Voting Rights Act, but the Fourth Circuit saw it differently. And in an opinion, earlier this year, the Fourth Circuit struck down all of those provisions, all of them, on the grounds that they were intentionally racially discriminatory. So they didn't even get to Section 2 of the Voting Rights Act. They said all the evidence in the record shows that this was done for racial reasons. And I think the famous quote from that opinion is the one that says these provisions targeted African Americans with almost surgical precision. But the more important core of the opinion is the Fourth Circuit's grappling and ultimate resolution of the question of was it race or was it politics, right? Were they just suppressing Democrats because they were Republicans, and is that okay? And what the Fourth Circuit said was that all the evidence in the case cumulatively and unmistakably reveal that the General Assembly used the law to entrench itself. It did so by targeting voters who, based on race, were unlikely to vote for the majority party. Even if done for partisan ends, that constituted racial discrimination. And, it's clear, right? In our legal doctrine, we don't say the government can use race as long as it's for partisan reasons. There's no partisan exception to the Equal Protection Clause. So with that decision, we were then scrambling to put in place more early voting hours. The other measures were pretty easy to just eliminate. But immediately, in our state, the party of the governor controls the state elections board and all 100 county election boards. Memos went out from the state party chair telling those local boards, we want you to restrict early voting as much as possible. So then we were suddenly thrown into this scramble. We have 100 counties. Not all of them passed early voting plans that were extremely restrictive, but in some counties, Wake County, for example, they had one early voting site the first week for hundreds of thousands of voters who had previously voted in the first week of early voting. So we were scrambling to find attorneys who could represent the minority board members, not racial minority, but it's a 2-to-1 partisan split on our local election boards. That one member who was advocating for larger hours and more early voting sites, we needed attorneys to represent them, and we found some. And the kinds of evidence that we were able to put forward was to show, for example, in some counties, they were closing the early voting sites where African Americans lived within a 1 or 2 mile radius of the site and keeping open the ones that were in the all-white parts of the county. I mean, there was no subtlety about how they were arranging early voting. The results ultimately were mixed. That is, we won some of those challenges, others we didn't. But it set the stage then for an election season without the full opportunities to vote that should have been afforded. In addition to all that litigation going on, we had 2 NVRA cases filed in our state, one about the failure of registrations, DMV to register people the way they're supposed to, and then right before the election, an NVRA case filed about improper purging. And here, private citizens were going to the local boards and saying, we sent out all these mailings and some of them came back, so we want you to purge the people whose mailings came back. So they were having hearings and purging voters right before the election. So then during election, the wide range of voter suppression things that happened were not just these statewide systemic issues. We did have intimidation at the polls. We had people who were spit on because they were campaigning for a certain candidate. We had the first day of early voting in Durham, we had someone show up at one of the early voting sites videotaping church vans and cars as they came into the parking lot and making notes of license plates, wearing this poll observer badge that they had made. And so we were able to shut that down, but it did go on. And it created this atmosphere of intimidation. We had witnesses who saw people, an elderly woman, for example, come up to a polling place in a cab, and someone with a Trump mask went over to the cab, and then they left and didn't vote. Just a lot of mischief at the local level. And we had dirty tricks, things. I represented 2 voters in Johnston County who, when they went to vote for early voting, instead of being able to fill out their ballot, they were told that you don't have to fill it out because you've got a Democratic ballot. It'll just be voted. Now you think, well, why would they believe that? Because prior to this monster vote suppression law, we had straight ticket voting. And it used to be true that you could go and just blacken one of those ovals and that's all you had to fill out for your ballot. So it wasn't entirely unreasonable for this elderly African-American couple to believe in Johnston County, where there is Klan activity, for them to believe that they had done enough by just filling out one oval in their ballot. And they ultimately, when they got back to the car and the person taking the poll said, well, that went fast. And they said, well, we only had to fill out one because we got a Democratic ballot. And the driver of the car said, wait a minute, that's not what happens in a general election. Tried to get it corrected. We've had a hearing in front of the Board of Elections. Another opportunity, we could have an attorney go to the Board of Elections with these voters and say, this is what happened to them. We don't know how it'll ultimately turn out because we don't have the canvas yet. But those are some of the kinds of things that went on Election Day. Where we are now in the state is that our gubernatorial race has not been determined. We had over 50,000 provisional ballots, and the margin of victory for Roy Cooper, the challenger, is only 5,000 votes. So we are now trying to find attorneys to go to the 100 counties for their pre-canvass provisional ballot meetings, where these 3 local board members will make a decision about whether or not to count these provisional ballots, and essentially making legal determinations about whether or not the voter met the requirements to have that provisional ballot counted.
Are these primarily people that have to show up after the election day and provide some additional?
There are a range of circumstances, like getting into the weeds is really complicated.
Okay, well, maybe it's not worth it.
No, but some of the people are people who didn't have HAVA ID and could go back. Some of the people are people under this injunction where if they went to the DMV but they weren't registered, that ballot should count. So, but the other thing I briefly want to tell you about is Durham County, morning of the election, 6:30 in the morning, people show up at the polls, and the machines, some of the e-poll books, electronic poll books, were telling the poll worker that person had already voted, which is isn't really, it wasn't possible at 6:30 in the morning. So they realized pretty quickly that they had a problem with these e-poll books telling people they had already voted, and also telling the poll worker to ask for ID when they weren't supposed to. So instead of troubleshooting the 5 precincts where this was happening, the State Board of Elections, and understand the director of the State Board of Elections is not only married to a chief attorney for the Republican Party, but she would lose her job if Roy Cooper, the Democrat, wins for governor. She tells Durham County to shut down all of their electronic poll books in all 57 precincts in the county and use paper poll books. Poll workers weren't trained on how to use paper poll books. They quickly ran out of these forms that they needed. Voting was shut down for 2 hours in some cases. So we went to court. We went to state court in the afternoon. I was calling around. I needed an attorney in Wake County who would go with my attorney to get these papers filed before we could drive to Wake County. And the judge did not agree with us to extend polling hours so that more people could vote. The State Board of Elections extended polling hours in a few precincts, but another opportunity where we needed someone locally who doesn't do voting rights all the time, but And I'll just say in that little hearing, I had my attorney, one volunteer attorney I found. The other side had literally 20 attorneys. The Republican Party had brought in folks from Virginia and South Carolina, and they were lawyered up. They wanted to intervene in the case.
That's probably a fair fight between you and I know you, Anita.
So for the future, what are we looking at? Big question, can we keep at bay these vote suppression laws? The Fourth Circuit's opinion is likely, we don't know yet whether the Supreme Court will take this up, but can we defend this opinion and can we keep at bay similar measures? And I just have to say a quick word about redistricting because that's also on the horizon, and that's another way in which attorneys can play an important role in making sure we have a fair democracy, a democracy that counts everyone's ballots and gives them all the same weight. So I'll stop there.
Thanks, Anita. I would just comment that, this whole point you made about the essential holding of the Fourth Circuit, that you can't accomplish political means, ends through racial means, is also kind of implicated in the other North Carolina case that's up in the Supreme Court now, which is the racial gerrymandering challenge to the congressional map. North Carolina is a font of litigation. It's a remarkable thing this year, but there the argument is we didn't draw these districts. This is the same old sort of Shaw kind of claims. We didn't draw these districts for racial reasons, we drew them for political reasons, and that the Supreme Court's going to try to sort out that relationship, hopefully in a positive way, but who knows at this point. All right, so our third wonderful speaker is State Representative Kathleen Clyde. She represents 75th Ohio House District, which covers central and southern Portage County. I told her I had to look up where Portage County is. It's somewhere between Akron and Youngstown in the greater Cleveland part of the state. Kathleen serves as ranking member on the Government Accountability and Oversight Committee. She's also a member of the Finance Committee and its Transportation Subcommittee, the Public Utilities Committee, the Ohio Constitutional Modernization Commission, and the Ohio Ballot Board. Prior to joining the legislature, she served as Deputy Legal Counsel to the Speaker of the Ohio House, where she worked on legal issues ranging from access to the courts to voting rights, and was a member of the Board of Directors of the Columbus ACS chapter. She's a noted expert in election law and has spoken on election law issues at the Ohio State, Capital University, Stanford, and Harvard Law Schools. She earned her bachelor's from Wesleyan University in Connecticut and her JD from Ohio State, where she was a leader of the ACS chapter, as you can probably imagine. Thank you for coming to enlighten us about the events in Ohio, Kathleen.
Thank you very much. It's great to be here with you all, and thank you to ACS for inviting me and for being so helpful as I fight away in the heartland on many of these critical issues. And thanks for the opportunity to be on a panel of such great experts and predominantly women. That's not usual for me, especially coming from Ohio, to be on a almost all women panel. Paul, we're glad you're here too. But I just had to note it. It's very exciting for me. So I wanted to say, Ohio really had its moment in the spotlight for voting rights issues starting in 2004. It was certainly Florida in 2000 and Ohio in 2004. And I was working on the presidential campaign that year and couldn't believe what I witnessed. We had lines 4, 5, 6 hours long to vote. We had a very partisan Secretary of State who was also chairing the Bush-Cheney campaign at the same time as running Ohio's elections, throwing out people's voter registration forms if they weren't on a heavy enough card stock. We had the average wait time in the 2004 election for an African-American voter was 58 minutes. The average wait time for a white voter was 12 minutes. And the last person in the country to vote in the 2004 election was a Kenyan college student who waited in line over 12 hours to vote because the 2 voting machines in that precinct went down for most of the day, and a whole group of young people, their vote was important to them, and they waited, and they were among the last people in the entire United States to vote in that election. So that certainly stuck in my mind, and that was something that I wanted to be a part of fixing. And I dedicated myself for the last decade or so to learning about election law issues, whether it be in law school. There's an election law center at The Ohio State University. I clerked at the Brennan Center for Justice and with the Democratic Secretary of State in Ohio. I became an election official in 2008 after I graduated from law school, so got firsthand experience setting up and running an early vote center in Franklin County, which is where Columbus, go Bucks, is. And we had 65,000 people cast their early vote there, so I got that exposure to the voting process. And in 2010, I was the youngest woman elected to the Ohio General Assembly, and unfortunately the Republican wave came across Ohio, and I have been fighting very hard against constant attacks on the right to vote in Ohio. And I'll talk a little bit about the overview of problems in Ohio leading up to 2016. We had nearly 20 voter suppression bills introduced in the legislature in the 2-year period before the 2016 election, 8 of which were signed into law. The first one made the referendum process for rejecting a bill at the ballot harder. So let's start off with making the referendum and the rejecting of legislation by the citizens harder before we pass a whole bunch of other bad bills. It was quite the strategy. We had a bill that eliminated the minimum number of poll workers required in certain elections and that certified e-poll books, although there were a number of problems with e-poll books throughout Ohio. We had a bill that limited ballot access for minor parties for statewide office, and that one was dubbed the Governor Kasich Election Protection Act because there was a libertarian rumored to run against him, so they were trying to limit access in that way. We had a bill that expanded the Secretary of State's authority to use other databases like the Interstate Compact database to identify voters for purging and increasing the amount of purging that could happen in Ohio. And it also loosened the minimum requirement of voting machines needed to be in each county in Ohio. Next, we had a series of bills that made it harder to count absentee and provisional ballots in Ohio. Senate Bill 205 prohibited boards of elections from paying return postage on absentee ballot envelopes and also adopted a perfect form requirement, as we're calling it in Ohio, where you are required to fill out a lot of information on your provisional or absentee ballot application and envelope. And if you make any mistakes or transpose anything or leave off anything, your ballot will not be counted. We did that for both absentee ballots and for provisional ballots, and also prohibited the counting of provisional ballots cast in the wrong polling place, usually because a poll worker directs the voter to the wrong polling place. We had a bill that eliminated the first week of early voting in Ohio. And then we had 2 provisions stuck in 2 different budget bills. One in our operating budget that would have forced universities to charge out-of-state students that assist with voter ID in-state tuition or face severe financial penalties. So it would have made it very difficult for universities to help students have the ID that they need to vote. And the second, we were able to get that vetoed. The second provision was slipped into the transportation budget. And it was a provision that said anybody that came from out of state and registered to vote in Ohio, say a college student, they would have to, within 30 days of registering to vote, turn in their out-of-state driver's license and get an Ohio driver's license and retitle their vehicle in Ohio within 30 days of registering to vote, or face a criminal penalty of up to 6 months in jail and a $2,500 fine. This was proposed by the legislature. I opposed it aggressively and called it out for what it was, a voter suppression, yet another voter suppression measure. I was told they were just trying to update the motor vehicle code, but we were able to get a quiet kind of pocket veto, line item veto of that provision from my not always close friend, our governor. So just relentless efforts to make it harder to vote in Ohio. And we've also had a fair number of administrative actions that have made it difficult to vote. Efforts by our Secretary of State to instill uniformity and really use that as an excuse to get rid of evening and weekend early voting hours. He tried to eliminate the last 3 days of early voting, and he set uniform, crappy hours for early voting across the state. He purged more voters than any other state. We had over 2 million voters purged in Ohio in the last 5 years alone, more than any other state in the country. And he is also very aggressive about throwing out people's votes once they've been cast. We are in the bottom 5 states for our rate of rejecting ballots. We had 47,000 ballots get thrown out in the 2012 election before we put all these bad laws into place that will make it harder. We've had a lot of litigation in Ohio. Some of it has been helpful. We had the Obama v. Husted, the NAACP v. Husted, and the Ohio Democratic Party v. Husted, 3 lawsuits dealing with early voting to fight for those evening and weekend hours and to keep the last 3 days of early voting, which are the 3 busiest days. And we were successful in those lawsuits, thankfully. We had the NEOC v. Husted lawsuit. Husted is our Secretary of State in Ohio and hopefully never our governor. But we tried to challenge his vote rejection rates, and our successful case was our purging lawsuit, the APRI v. Husted lawsuit, challenging the purging of people simply for not voting often enough, using provisions in the National Voter Registration Act to protect. That bill was adopted to get more people registered, to help bring more people into the process, not as a tool to strike them from the rolls and thereby disenfranchise them unless they know and take the time to re-register. We had one other case that you may have heard about in the primaries. Secretary Husted decided to stop letting 17-year-olds who would be 18 by election day from participating in our presidential primary. That's an option that young people have. If they're going to be 18 in November, they can vote, and it's an exciting first-time voting opportunity for them that was kind of taken away in a sneaky way in a poll worker manual. A voter contacted my office to say that he had been turned away when he tried to vote at 17, and we came out strongly against it. Myself and my Democratic colleagues in the legislature, a friend of mine who's also a member of ACS, filed a lawsuit in court a couple days later, and a few days before the election, the primary election, we were able to restore the voting rights for about 16,000 17-year-olds across Ohio who would be 18 in November, and many of them turned out to vote, and I think will be voters for a long, long time because we fought for their rights. So that was leading up to, all of that was leading up to November. Just a very brief snapshot. We had our lowest voter turnout since 2000 in Ohio, with only 64% of voting age Ohioans participating in the election. We did have thousands of paid and volunteer lawyers on the ground in Ohio, partisan and nonpartisan, monitoring and helping with voting issues in the election. We experienced long lines in different areas throughout the state, especially in student areas and in our inner city areas. We had thousands of calls to a hotline that we had set up reporting incidents and just asking questions because of the confusing mess of laws that have been passed or that have been discussed, so people are not clear what the laws actually are. And we have problems getting voters to the correct locations, and we are worried about this rejected ballot problem. That's still being sorted out, as is the case in North Carolina, but we'll certainly be monitoring that and trying to get these votes counted.
You have one race there that's really close, right?
We have one statewide very close race, a state Supreme Court race. So we are likely to have a statewide recount, which that will be a fight and an opportunity for us to challenge a lot of these restrictions, which could be very helpful going forward in Ohio and vindicating voter rights. So I'll leave it at that. Lots going on in battleground Ohio, and appreciate your interest in the efforts across the board to protect voting rights, and we shall continue in the struggle.
Right. I just note, I guess, that unless I'm mistaken, you know the answer. You know the answer. This Ohio's never been a state that was covered by Section 5, right? So this was the Shelby County story doesn't really affect the ability. There are states outside of that group of states. Another one clearly is Wisconsin this last few years, which have been as aggressive about trying to suppress the vote of minority voters as any southern state has ever been, right? Well, maybe not ever, but in the same time, yeah. And so, I mean, to some extent, we can blame the court for a lot of this, but not for all of it. Some of it's just plain politics that people have been playing. Tell me a little bit more about Election Day, Kathleen. I know there was a great deal of concern, at least in the partisan circles, about the thugs at the polls and the voter intimidation. Indeed, an injunction was granted by a federal judge right before Election Day to prevent people from doing that, right?
It was actually stayed.
It was granted, but then stayed by the Sixth Circuit, right? Yeah.
Exactly. So we haven't yet compiled our, huge list of incidents that were reported in. I mean, there are certainly some troubling reports, much like you heard from Anita and about what happened in North Carolina, but a lot of threats of voter intimidation in Ohio, and certainly reports of it happening in various places.
Right. And that stay from the Sixth Circuit was then left in place by the Supreme Court. One of the things they decided, not just in this case, but in Arizona litigation and others, is we don't want federal judges entering changes in the voting laws in the last 2 days before the election. And that's a consistent position the Supreme Court has taken. But it does leave you kind of defenseless at the last minute when something new crops up.
Can I say something? I just want to say something about the voter ID point that you made, Paul, just to
Sure.
jump in for a second. While it is true that the proliferation of voter ID laws it doesn't have a direct link in non-Section 5 states to Shelby. It is also true the Supreme Court's decision in the Crawford decision out of Indiana was it? I'm sorry, because it was the one that Paul lost. So we can blame him. Sorry, I shouldn't even. Sorry, but it is true that it appears. I mean, even though the decision in Crawford, because the Crawford case was a facial challenge to the statute. It was before it had been implemented. It was very difficult to establish the impact, and subsequently judges, including judges that ruled against us in Crawford, like Dick Posner in particular, have come out and said, gosh, I wouldn't have voted to uphold it if I'd appreciated the impact it would have on minority communities. But the fact is that the headline that people took away from Crawford was that really restrictive photo ID laws are okay. it's okay to do this, even if, that it's okay. So I think that was kind of another threshold moment in our sort of the march toward the court not being helpful in protecting the right to vote.
That's true. On the other hand, I think it's important to recognize in the last year or so, the federal courts have become newly aggressive in
Right.
a good example is the one Anita mentioned in North Carolina, the Fourth Circuit reversing findings of fact and saying the evidence on its face can only lead to the conclusion that this was done for racial reasons. And the Texas voter ID case
That's
is another
exactly
one
right.
as well.
And
Now, whether that'll last past
that's the
the new
point.
Supreme
Well,
Court,
yeah.
I don't know. But
right, and it illustrates the point, as we talked about earlier, illustrates the point that in Texas you have a racially discriminatory voter ID law that's been in place for years, and that the remedy, because we've been litigating it, but unless you can stop it before it's implemented, the damage is done for years. And I think that the remedy that they have now, this interim remedy, is weak. It's unclear whether or not they're going to get a more effective remedy. And then in the North Carolina case, with all these other provisions, that it's really unclear what the future looks like, even if we do have federal courts around the country being willing to look at evidence of the impact of these racially discriminatory laws.
Yeah.
I don't think we're not, what is it, spiking the football? Whatever, I don't know this very well, but we're not doing that,
you really deploy those sports metaphors
Yeah,
really
I know,
well.
it's really,
very impressive.
But we're not doing that, right? We're doing this.
Yeah.
Right?
We have a cert petition that's been pending in the Texas voter ID case for a while, and I think most people thought before the election it probably wouldn't get granted. I think there's a lot of concern now that it will be granted, and so that could be a chance for the Supreme Court to weigh in. In North Carolina, the governor has sought multiple extensions of time to file a cert petition in your voter ID and other early voting problem case coming out of the Fourth Circuit. Is there some sense that if the governor ends up losing, and that case will not be pursued in the Supreme Court by the Democrats?
Yeah, so I wish I could give that some credence, but unfortunately, no. So even if we do have now a Democrat Attorney General, but the legislative leaders who enacted the law are also defendants, and they have their separate, independently retained, paid for by the state, attorneys and they can choose to continue to appeal even if the governor and the Attorney General don't want to.
Yeah, I guess I'm doing the House Bill 2, the bathroom bill case down there. We have the same problem with these legislative leaders. They're quite aggressive, and they have a lot of power under state law to intervene and represent the state. It's an unfortunate fact. Do you want to just spend a minute talking about what's going on with the governor's race in terms of trying to figure out who won that case? I mean, the fact that it's going to go to the General Assembly?
Well, I hope not. But so the issue is, under state law, if the margin of victory for a statewide race is less than 10,000 votes, then a recount can be requested. We actually don't know what the margin will be because we have all these outstanding provisional ballots. We know that not all of them will count, but depending on how the extent to which the local boards appropriately interpret the law and decide whether to count those ballots, what we do know is that they are disproportionately in many counties, African-American ballots. So African-Americans were forced to vote these provisional ballots. Separate and apart from how many of those 50,000 provisional ballots will count and what will the ultimate vote count be in the gubernatorial race, and will it be under 10,000 that allows a recount? Apart from all of that question is a protest that's been filed by Governor McCrory in Durham County. He's, despite not wanting to leave the polls open longer because on election day he said everything was fine, there were no problems. He's now saying, his attorneys are saying, that there were optical scan machines that malfunctioned. And so we can't really know the vote totals from Durham County. If there is an election protest and under state law, it goes to the General Assembly to decide that protest. The Board of Elections does not decide the protest. The General Assembly under state law has the power, if they conclude that they cannot determine who the winner is, they can order a new election. Or they can say, here's the votes we're going to count, and counting those, here's who the winner is. Whatever they say is completely unreviewable by any state court. So the General Assembly has the final say.
interesting things to watch. We were talking about where to go to try to fix these problems now, and I think Julie rightly ruled out Congress at least for a while. And the federal courts, I guess it'll remain to be seen what the Supreme Court does in North Carolina and Texas. You for a while were pursuing cases on the redistricting front in state courts. Is that something that people should be thinking about as they try to figure out what to do about these problems in a lot of other states?
Well, I do think that there are promising avenues at the state level. You have to assess, where the case will end up. And we actually, one bright spot in terms of for those of us advocating for voting rights was the fact that we do have a state case against the voter ID. So even if the if the U.S. Supreme Court were to reverse the Fourth Circuit, we still have pending a claim that the voter ID violates our state constitution, which sets out the qualifications for voting. And our contention is that if one of the qualifications for voting is that you have to have an ID, if you don't have this ID, you can't vote, then that's creating a qualification, and the Constitution creates the qualifications, the legislature can't. That's our state constitutional claim. Michael Morgan is the judge who's just won for the state Supreme Court, which would give us we have a 7-member state Supreme Court that would give us a 4-3 Democrat-Republican balance on the state court. Unfortunately, the Republicans are now talking about, in the next 2 or 3 weeks, appointing 2 more members to our state Supreme Court so that they can retain their Republican advantage there. So there's always politics in the state courts, but I think that not only litigation-wise, but also in terms of demonstrating what works, demonstrating what enfranchises people, what allows African American, Latino, and other voters of color and other traditionally disenfranchised voters, that the states are really a good place to get those things done. And there's states that do have referenda and other ways that the public can do that, even if the legislature isn't inclined to.
Mm-hmm.
So I saw a picture of a protester on blog this morning that said voter suppression starts at the Electoral College. Does anybody want to comment on whether the Electoral College is another aspect of vote suppression after this election? Or I sort of sprung that on you a little bit. It does seem to me that you can make a pretty good argument that a system of election that says that some states voters just don't get counted very much and nobody campaigns to them, and is a bad system of election. And when you end up with results like we have, where popular vote victory doesn't count twice in 20 years, that's quite remarkable, actually. But it is a problem that has to be solved in other ways, I guess.
I think that's right. I mean, whatever we want to think about it, it's not useful at this moment because we're not changing it at any time.
Actually, there is
I know the state compact
interstate
thing.
compact
Yeah,
thing,
but we have, if you look at the map about state legislatures around the country right now, we're not in a place where we would have a lot of state legislatures that would be open to this
Given
kind
that
of exactly.
Yeah.
So we have such one-party control in many states by folks who are not interested in sort of democratizing the presidential election in that way. So
Just so people understand, this is a compact where the states would agree in advance to send their electors to vote for whoever wins the popular majority.
The nationwide popular vote.
Nationwide popular vote, yes.
So it's a way to create a national popular vote driver for the result without having to have a constitutional amendment. And some states, Maryland, I think, has joined into the compact. So they're my state. But there are some states that have. But
a number of states have,
yes,
10 or 11 states
But you have to
I
have
think.
the state legislature do it.
And their obligation to do that only triggers when they have enough states that have done it, so that they would
Exactly.
control the majority
Exactly.
in every election. So
I mean, it's a good idea, I think, but it's
a
sort
nice
of,
workaround, better than trying to amend the Constitution,
Yeah,
that's for
right.
sure. I think on that note, we'll do some Q&A from you folks and see what you're interested in. There's some microphone people. Oh, there you go. I'll let the microphone decide whose question gets asked, because that's what they told me to do in this note. So.
Thank you for the discussion. I have two questions. One, specifically to Anita, you mentioned that you still could use volunteers in North Carolina. Can you be, specific about what it is you'd like volunteers to do, the dates, and if it's somewhere available already, let us know that. But I think it would be important to just provide that information, because I'm sure we can find some volunteers. The second thing is, there's been a defensive posture for so long in the voting rights community, fighting ALEC and other, state actors. Do you think there's going to be a shift, now to be more proactive? I understand that their state majority issues are at play, but it seems to me there needs to be a more aggressive posture taken on expanding the vote and talking directly to the electorate, because that's what happened this cycle. Voter fraud has now, been elevated not just to state discussions, but to a national discussion. So is there going to be a pivot, you think, in the voting rights community as a result of this election, and how can individuals, not just lawyers, but how can individuals help with that?
Well, thank you for the question about more specifics. So there are things that attorneys who are licensed in North Carolina can do. And then if you're not in North Carolina, so those things would be, for example, if you are in North Carolina and licensed, sign up to help us monitor the counting of ballots, both the provision and the challenges from our point of view is it's not uniform. I can't tell you that every county in the state is going to have their pre-canvass provisional ballot meeting, on this day at this time. So we're coordinating it. We've done some trainings already. We've got PowerPoint trainings, telling people what we need them to look for, what the governing statutes are. But that's really, it can be in North Carolina and are licensed so that you can advocate as an attorney there. That's one set of things. And I would say that right now the way to get plugged in is to email Anita at scsj.org. In terms of, if you're not in North Carolina, if we end up having litigation, there's a lot of things like helping draft briefs, interviewing witnesses and drafting affidavits, that kind of volunteer work that can sometimes, not always, but can sometimes be done through email and phone calls. So if you're interested in that kind of support work, that could also be useful.
And just as Anita's story illustrates, I think by the time we get to the next election in a couple of years, everybody who has any availability should try to get hooked into some effort to protect the vote in advance of the election if they can, either through partisan or nonpartisan, whatever your choice is. But there are multiple opportunities, and part of the purpose of the Voting Rights Institute is to get the word out to people and get people connected to a network where they can find the best opportunities to do that. So I urge people to try to find some time going forward to be on the protection side of the voter protection fight.
Right, and I do want to say that I think that work, both the work of the Voting Rights Institute and the work of the Lawyers Committee for Civil Rights Under Law that coordinates the election protection work across the country with other partners like at NALEO or at the NAA Legal Defense and NAACP Legal Defense Fund. And I know they're thinking right now about how they can take the energy of the Election Protection Coalition. Is anyone here from the Lawyers Committee? I don't see anybody. But how they can take, how they can take the energy of, here I am plugging you, of the election protection effort, both lawyer and non-lawyer work, and turn that into sort of a year-round, even more of a year-round effort to work on litigation and policy in conjunction with other assets that we have here. And there is actually a proactive agenda that has been focused on the states for several years now around trying to get same-day voter registration, early voting, automatic voter registration. There are lots of efforts from grassroots groups with some support from national groups to try and have these movements be about something in the states that is affirmative and around expanding the electorate and all of that. So I think that work is ongoing. It's sometimes hard to see, and there has been some success in some states. So I think we just have to redouble that and in terms of what we can give people to do, because lawyers and non-lawyers can work on these policy fights at the state level and organizing in multiracial coalitions in their communities.
Let me jump in. I made a little list on my way here of ways lawyers can help. And just to piggyback on what was already said, be a poll worker is one way that can be very helpful. Bring that average age down from about 85 in Ohio in your lawyering skills to very important work. Be an observer. I think people think that can be boring. And it's good if it's boring, because that means there isn't a problem, but it's so critical, because if there is a problem, we won't know about it in Ohio unless an observer calls in and tells us. If you work for a big law firm, consider doing pro bono work in the voting rights area. I've had to make calls to try to find help on these major cases. Support organizations like the Southern Coalition for Social Justice, DEMOS, Advancement Project, the NAACP, the Brennan Center, the Lawyers Committee, and ACS. Support candidates who support expanding access to voting. Read and stay up to date on these issues. Follow Ari Berman. Follow Rick Hasen. There's a number of others, us. I know I tweet and write on Facebook about what's going on in Battleground, Ohio. And then finally, participate in your state legislatures and in activating others to do the same. Often the voting bills that pass in the chambers in Ohio, no one's at the committee hearings. There's not much coverage. And lawyers, you have the expertise to come in and to testify, to activate faith groups or other groups that you're involved in that care about voting rights, to let them know about a process that's a little foreign to them, but that they care deeply about. You can be citizen activists too.
Just last, I forgot to also say, of course, ACS. I was thinking, like, who did I not think about? ACS has this powerful national network of lawyers around the country, law students and lawyers. And if that energy can be part of what we were just talking about, that's a powerful part of leadership that everyone can do.
Hi there. This is probably for Julie, but if any others have thoughts, I'd be interested. I want to project forward to the incoming administration and get you all to think about how voter suppression or vote suppression might change, not only with the absence of Shelby, but with the presence of people like Attorney General Kobach, if the rumors are true. So what can the federal government do to make things worse in the coming years, and how can we as lawyers, as organizations, defend against that?
Yeah, I've been thinking about that, Brian, a little bit. And I think that we need to do, so there's more thinking to be done in general. But I do think one of the great things, I'll say first, is that the private bar is much stronger now than it was the last time we faced an administration coming in that had voting rights in its crosshairs. So I do think I'm comforted on some level about the strength of what we have in the field to be able to litigate ourselves and not have to rely on the Justice Department to be litigating for us. Right now, we're litigating much, 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 much more than they are anyway, as you know. So we're there being able to try to protect rights. But actually, the thing that I thought about in the voting space that I'm a little concerned about are Section 8 purge lawsuits. That there may be lawsuits brought under the NVRA to purge voter rolls. And I think there are also going to be legislative efforts in Congress with the support of the Justice Department, perhaps, to sort of make changes to the NVRA, to weaken it, to also further weaken the Voting Rights Act, to enact, I mean, I hate to say these things out loud, but to sort of, because they're not secrets, if you just look on the certain websites and you'll find them, to have impose a nationwide federal strict voter ID for federal elections, which would then become a strict voter ID for all elections, or a citizenship, documentary proof of citizenship requirements for voter registration across the country. So I think we have to worry on the litigation side. It may be sort of, we may see the worst thing we might see are these Section 8 lawsuits, because the other stuff is sort of you're just not doing it. And even if there are lawsuits that we don't like, I don't think that's going to be that's not my nightmare right now. But it is maybe some of these legislative efforts that could have legs under an adverse to voting rights administration.
There's another guy here right in front of that guy's gentleman here has been trying to get a question in. You, yeah.
Okay, I can just use my voice.
Okay.
Okay, so here's, so I know that in both North Carolina and Wisconsin, the gist of the lawsuits involved racial discrimination, or either in effect or intent or aspects of that. And I'm just wondering if there are theories of fighting voting suppression which don't turn on proof of racial motivation or racial intent. And just by way of illustration, I know that in Wisconsin they had several elderly African-American women, for example, who said, who detailed the burdens they had of not being able to get their driver's license from some other state. And it occurred to me it really shouldn't matter if that's an African-American woman or an elderly white woman. And I'm just wondering if there are
theories.
If there are theories, and I don't know if that's too much in the weeds for this particular issue.
Both of those cases, there are already right-to-vote arguments being made, separate and apart from the racial disparity arguments under Section 2 of the Voting Rights Act. They're basically trying to litigate the Crawford claim and litigate it better than it was done the first time around when it went up to the Supreme Court, and make a better record on the kinds of burdens on voting that are being created by these ID laws, and invoking the balancing test that the Supreme Court has established in this area, the Anderson-Burdick test, which says the burden on voting is much more severe than the value of whatever state interest is being served. And so people are continuing to try to keep that claim alive, and I think there is hope, at some point that we can get a court to take that really seriously.
We certainly advocated the Anderson-Burdick claims in the North Carolina case pretty strongly. So sections of all of our briefs had that claim. And it was interesting, in the very first preliminary injunction hearing, it took a while to get our federal judge to wrap his head around the fact that we actually did have a claim that wasn't a race-based claim. And I think that it kind of ties into the answer to the previous question, because you're absolutely right that voter ID disadvantages people with disabilities, elderly people, homeless people, women who change their names when they get married, victims of domestic violence so there's like there's a wide range of individuals who are disadvantaged by that law and by some of the other voter restrictions. And maybe one of the ways that we ultimately fight off this bad legislation is to make clear that they're going to hurt a wide range of constituencies, and that can be a valuable message to put forward.
Voting Rights Act?
No, it's under the
No.
Constitution.
Just under, okay.
And that's part of, goes back to the beginning with my air quotes, is that the court really has given first of all, the court said in Bush v. Gore there is no right to vote in the Constitution. Remember that. And even though some courts have sometimes given lip service to the right to vote in the Constitution, they actually don't treat it like it's a right. And that's an issue that we have, because that's what I was alluding to before when I was talking about the right to bear arms. The court does not subject the right to vote, infringements on the right to vote, to the same level of scrutiny as they do infringements on other fundamental rights. And that's a problem.
Okay, and in a related theoretical way of approaching the issue, are there any civil damages theories against legislatures or government officials who conspire to deprive individuals of the right to vote? Have those ever been pursued? In other words, 3 people get in a room and say, let's not put voting machines in community X. Why shouldn't, if they conspired to deprive somebody of their civil rights if they were 3 police officers and they were conspiring to deprive somebody of their civil rights otherwise, you could do a Bivens case. I'm just wondering if there's ever a civil damages theory which has actually ever been pursued against people acting under color of state law to deprive citizens of the fundamental right to vote.
But I think the answer is no, and we could talk, but I think part of it in your premise, you're premising this notion that we have a right to vote the way we have a Fourth Amendment rights, and we don't. That's my point. Is that the court does not recognize our right to vote to be fundamental in the way that it recognizes other rights as fundamental. It doesn't treat it that way. So yeah, in theory, you could have a conspiracy or like, yeah, a 241 or what, you could do all kinds of things. But
1983 case.
yeah, or 1983 case. But in doing that, the threshold issue is they have to treat it like it's a fundamental right. And they don't.
The other thing is, once you add damages into the mix, there's a million other defenses that make it actually harder to win than the injunctive case.
Oh, right, because with your 1983,
Immunities
exactly.
of all sorts,
You have
qualified immunities
right.
and things, yeah.
Exactly.
But the effect on public officials to behave, okay, just throwing it out, just
Yeah.
asking, that's all.
Yeah.
Hi, thank you so much for presenting. I think that this was very educational for all of us. One of the things that I'm thinking a lot about is just as we become more technologically advanced, the types of, the ways that the vote is suppressed are going to get more innovative and creative. And I think we saw that with the talk about fake news on Facebook targeting certain voters. And so I was just interested in whether or not there's any work being done to look more closely at technology and the ways that technology can be used to affect and suppress certain people's votes.
Man, this is the first.
Both technology and social media, because I know that technologies can be used to sort of pinpoint certain communities for gerrymandering, for figuring out which polling places to close, et cetera. And then there's the social media, Facebook, et cetera angle.
I would just say this is the first election I remember where there was a massive amount of concern about hacking and a realization that we need to make sure that the machines have a paper record and they're not running on 20-year-old software and things like that. That is clearly an effort that's being undertaken. It's not so much about any particular. I mean, maybe it could. Hacking could be used in a way that would distort elections. I'm not sure of any of this that actually happened this year, but there is going to be a modernization of the voting system itself to try to minimize that, and it's ongoing. I'll let others comment on the social media aspects of it, though.
Well, I would just say that I do think there are efforts to both be aware of where that's going on, but also to use social media to protect the right to vote, right? So 20 years ago, when we were monitoring problems at polling places, if there was a report of somebody doing something, you had to send a witness out there. Now you just say, take a picture of it with your cell phone.
Put it on Facebook, right?
So learning how to harness the power of technology and social media to support protection of the right to vote, I think, is also something that we're doing.
We had a problem in Ohio, I know, of people being told that they could text their vote in. And we've had problems in the past. Ohio doesn't have online voter registration, and one of the many ways we're in the dark ages. But people will go to a national website like Rock the Vote, where many states do, and they'll think that they've registered to vote and find when they're past the deadline that they're not registered to vote. So we've had to manage some of those difficulties, and it's definitely, I think, disenfranchised some voters, and something that we have to work hard to think about and reach out to people in an effective way. We also have had some issues technologically, one with e-poll books and two with the online voter registration system that we're about to adopt. We waited until the major presidential election was over to put that into effect. But for both, to online register in Ohio, you have to have a driver's license. So it's a photo ID requirement to register. Some states have that, but it's kind of an end run around having a photo ID requirement for an important step in the voting process. So it's something I'm very concerned about And then e-poll books in Ohio, a lot of them have a swipe where you don't have to have a driver's license in Ohio. There's other forms of ID, but poll workers get in the habit of just asking you for your license so they can swipe it. And suddenly people think they have to have a photo ID, or poll workers just start only accepting that, and we run into issues there where voters are disenfranchised. So it's interesting ways that technological improvements have created other harms that we need to, I think, be on the lookout about.
Kathleen, were the various legislative proposals in Ohio homegrown, or were they courtesy of ALEC? And is there a counterpart organization that is devising progressive legislative proposals?
So ALEC is alive and well and very active in the Ohio legislature. I think the chair of ALEC's Ohio delegation is behind a lot of the voter suppression measures. This really came up first in 2011 when ALEC had an active voting section, which it now has somewhat abandoned, although their written material is all still accessible. And they also have done some work to limit ballot issues in states like Ohio, where that's really what progressives have left. Is, you know, we have a supermajority Republican legislature and Republicans in every statewide office except for one of our U.S. senators. So one of the few options left is to go to the ballot. So ALEC has helped Ohio Republicans think about ways to make it harder to go to the ballot. So these are all issues that that ALEC has either directly played a role in or I think been helpful. And yes, there are progressive organizations that are there to help progressives like myself. I've worked closely with the Brennan Center on automatic voter registration legislation. I've worked closely with the Brennan Center and Lawyers Committee and other groups pushing back against photo ID, and we've been successful. We so far don't have a photo ID only requirement in Ohio, and I'm very grateful to those groups, and I mentioned them because I think they're all worthy of continued support, and they do help us in the legislature to push back and to offer alternative proposals.
Thank you. As you alluded to, there have been efforts to use ballot initiatives to liberalize or repeal restrictive voting requirements. Do you see the opportunity generally for more of those efforts in additional states to have voters act in a pro-election, pro-voting manner?
Yeah, there have been some states that are looking at, because not all states have the ballot initiative process, and there's been work done in several states to look at things like felon disfranchisement as a way, right to vote initiatives. But I think part of that is doing the work on the ground to educate voters around what these things mean, why it's important to them, and then understanding how to talk about these issues in a way that resonates with voters. So yes, there's a group called the Ballot Initiative Strategy Center, BISC, and they're awesome. And they kind of do evaluations about where ballot initiatives are possible and what sorts of issues. They do polling around it. They do work with messaging and yes, on all kinds of ballot initiatives, and including issues around voting in elections.
The area where there's been a tremendous amount of activity of that kind is in gerrymandering, anti-gerrymandering, either in creating commissions or, like in Florida, establishing mandatory requirements for the districting maps that are pretty aggressively enforced by the Florida courts. So.
And I would say on the referendum side too, we've seen 2 photo ID initiatives reversed by the people. I know Minnesota
That's right.
and Maine
Montana.
or Montana. Okay.
Yeah, Montana. That's
So
right.
there is that possible pushback in some states.
Absolutely.
I'll say in Ohio, it's incredibly expensive to do a statewide ballot issue, and we've had the chamber and other right forces come out against a statewide redistricting initiative. For example, we were able to get one passed after, I think it was our 4th try, only dealing with the state legislature. It's quite a tough alternative in states as big and diverse as Ohio.
One
last one.
I was wondering about your thoughts about how to avoid what we saw this election with states like Wisconsin, Texas, and North Carolina failing to truly implement court orders that invalidated suppressive voting laws.
Can you solve that one for us, Anita?
It is a real problem, and I think we just have to keep putting our clients' experiences in front of the courts and pushing as hard as we can. So I don't, we certainly were filing in the Fourth Circuit mandamus petitions left, right, and center. We were using whatever procedures we had to say, the trial court is not doing what the Court of Appeals told them to do, and it did have some effect. Twice we filed them and then could withdraw them because the court did what we were asking them to do. So but the bigger picture problem, I almost feel like the courts are going to have to police themselves, and the way to do that is to put in front of them the record of what's going on.
Well, the other thing, I guess, is once these decisions have been on the books for a while, in the following election, at least, there ought to be a period of time when people can get all the rules clear, and you don't have this kind of quite as much of the sort of subtle civil disobedience going on at the local level that we saw in Texas, as well as I think in North Carolina too, right?
But it does really, not to say it again, but it does so illustrate how important it is to stop these things from being implemented in the first place, to have some kind of mechanism where statutes would have to pass some kind of voting rights or election-related initiatives, would have to pass some kind of scrutiny before you can put them into place, because the harm is just being done at every moment. Every moment that it's in place, the harm is being done, and there's no way to fix it. And we just don't, the kind of trench warfare that Anita is battling every day in the courts is extraordinary and not happening in many other places. So the momentum, you just lose your voting is not the area where you can have all of this happening and you're always in court. Meanwhile, all the discrimination keeps happening. It's a problem.
I was wondering if it was possible to get a contempt, case against a successful contempt case against an official as a deterrent in the future, but I'm sure that proof problems would be very hard.
Well, except that we have these we have the GOP chair sending out an email saying restrict early voting as much as you can. So some of it's timing, like you just don't have time to get into court and get your proof before the election's happening. But I think we can prove it, and we just have to work harder and be creative attorneys to show what's going on.
I guess we'll let that be the last word. Would you thank our wonderful panel, and thank you all for coming here.